I applaud that you're taking up the issue, quite frankly, because it's a difficult issue. Um, but I want to say that I'm here to note, and you have my written testimony opposing the four resolutions: 1752, CD1, 17163, 17164, and 17301. And the reason is because they raise serious legal concerns that you have to deal with. It's admirable that people want to try and regulate this area, and I get that, and I understand there's a lot of voices on both sides of this issue. But if you're going to regulate any area, you have to do so in accordance with the law. And the problem here is that the federal law creates certain protections and makes a lot of what has been pushed forward as these resolutions unenforceable and inappropriate. So let me just deal with it very quickly. First, you have the Communications Decency Act, which is a federal law, which says that you cannot hold an internet platform liable for the content of a posting by a third party. So it's like an advertisement. You can't hold a newspaper responsible for what people put in the advertisements. Similarly, some of these resolutions require a permit number or certain other content. That's going to be a problem. The CDA, Section 230, has been a robust protection for the internet and has allowed the internet to flourish. I personally have attempted to challenge that when I was serving as the Attorney General. We challenged Backpage for prostitution ads, but the protections afforded by the CDA say very, very clearly, and the courts have clearly upheld this, that you cannot hold internet platforms liable for the content. The second federal law that you have to worry about, and that the Corporation Council would have to worry about, is the Stored Communications Act, which essentially says you cannot force people to provide you electronically stored information, such as homes, rental addresses, rental contracts, things like that, without due process. You need due process, such as a search warrant or somebody who can take a look and say this is an appropriate request or not an appropriate request. That's a long-standing federal law from 1986. So the 1752, with all due respect to Councilmember Minor, when you ask for the hosting platform to provide these reports to say, well, you got to provide all this information, that's a direct violation of that law, because it does not provide for any kind of due process or search warrant. There is a Fourth Amendment problem with 1752. There are recent Supreme Court cases and recent federal cases preventing police from getting hotel information under criminal circumstances. The Supreme Court of the United States has said that those Fourth Amendment protections are very robust and cannot be used, and so you cannot get this information, even in a civil context. And finally, on 1752, let me just note, I understand that you want to, or the resolution tries to put enforcement into the hands of neighbors. That is a very problematic area, because you're going to pit neighbor against neighbor. But more importantly, just the legal concern of the way you've tried to do it is that it is in direct violation of the Hawaii Supreme Court law on mandamus. What you've tried to do is you've tried to say, well, if I'm a neighbor within 1,000 feet, I can force DPP, I can force the director to go and enforce this thing through a mandamus process. But the Hawaii Supreme Court has said you cannot use mandamus. You cannot, it's like if I want to call up and say, I don't like my neighbor, Ms. Sokugawa, you come down here and do something about that. Private citizens don't get to do that unless there's a very limited type of thing, which is mandamus, unless the only thing that the director has to do is ministerial. In this case, you're going to have a dispute. You're going to have people saying you violated the law. Other people will say they didn't violate the law. It's not going to be appropriate. So that's going to be a problem in 1752. The other resolutions, 17163, 164, and 301, set forth definitions of a rental agent and definitions of advertisements, which are problematic and violate, if they're going to be used in a manner against internet platforms, they will violate the Communications Decency Act and the Stored Communications Act, as I was talking about earlier. I don't want to repeat those, but it's problematic. And so, again, I urge you, if you're going to move in this area, and I applaud that, and Airbnb is committed to trying to work with the City Council and others in this area. But if you're going to do it, you have to do it in a manner that respects federal law and does not create legal challenges. So thank you very much for the opportunity.
Members, any questions? I just have a quick question. You know, you're saying that we should ensure that whatever we pass respects federal law, but federal law is not respecting our own laws right now. And so how does Airbnb feel about that?
Well,
because it is illegal to have a vacation rental unless you're permitted by the city and county of Honolulu.
And nobody at Airbnb is saying that you should not enforce the laws that you have. Mm-hmm. The laws of Honolulu, which have been passed, and as Director Sokugawa mentioned, can and should be enforced. But it is difficult. I grant you, it is difficult to use these old laws and to try and enforce them in the new circumstances that exist. Nonetheless, those are the tools that exist. I don't believe that the federal law is specifically trying to disrespect Hawaii law or Honolulu.